Hi friends, this is Prem. Today we are going to discuss about a very important topic. This message has been circulating in all the social media platforms like Facebook, X and WhatsApp saying that USCIS had revoked 60 days grace periods for the H1B visa holders. I don't know whether it's a real news or it's just like a social media news. So I want to discuss with attorney about this news. And also I want to discuss about the other topic. What are all the alternate options for the H1B visa holders if they got laid off? As usual, we are going to discuss all these things with our attorney. Henry is from Manifest Law Firm and Manifest Law Firm is providing a free consultation for everyone. So if you have any visa questions or any green card queries, you can call them. It's completely free and the QR code, you can see it on the screen. Hi Henry, thank you so much for your time and it's a very important topic and a lot of people are discussing about this one. I don't know whether it's a rumor, but in the social media, there is a discussion saying that US is not giving the 60-day grace periods to the H1B visa holders now. Let's discuss about that. Before that, எப்படி இருக்கீங்க?
நல்லா இருக்க எங்க
Yeah, I'm good. Thanks, Henry. Can you please explain about what is USCIS 60-day grace periods for H1B and whether it's an act or policy or whether it is available now?
This is really unfortunate news because I myself have not had any clients dealing with this yet, but the fact that it is surfacing on social media might be another trend where USCIS is making things more difficult for people. The 60-day grace period is mentioned in a subsection of the H1B regulations, and it says that someone will not be considered to be out of status for up to 60 days, but that DHS may reduce this at their discretion, which basically means that if USCIS wants to say no to a change of status, they do have the authority to do so when somebody is in their grace period. So the grace period is not 60 days always and guaranteed. And that means that if USCIS is really doing this now, that they are denying cases, then that means people should not wait for a full 60 days before they file something. But if you do know that you are getting terminated, you should start preparing a change of status case or transfer or extension as soon as possible to avoid this situation.
Okay, Henry. So you said it's available in the regulation. So this is not something new regulation. It is the old regulation and there is no changes on the regulation, right? In the recent days at least.
Correct. There's no change into the regulation itself. It just looks like, based on what people are reporting, that USCIS now is changing how they use that regulation. So for many, many years, USCIS has just not been very strict on that. So the regulation says USCIS may shorten the grace period at their discretion, and they just haven't been shortening it. They have always been approving people when they have gaps in their status for up to 60 days. But if now they are starting to say no to people who are filing for, let's say, H1B to B1 or B2, then that means that it might be a change in internal policy inside USCIS.
So I can assume that, okay, the 60 days grace period is there. If the person is in H1B, he got laid off like yesterday, whether he can count the day one from today?
Yes, so the 60-day grace period count starts from the last day that you worked at the job. It's not necessarily about when did you get paid, but it's about when was the last day that you were actually on the job. So, for example, sometimes people come to me and they say, hey, I haven't been working for 3 months, but my company just put me on leave. You know, that I'm still on the payroll, but I'm not getting paid as much as I used to. And they think that somehow that protects their status, but that's not actually true. If you have been benched, meaning that you're no longer working, even if you're still in the company systems, even if you're still registered on the payroll, then that is not actually you maintaining the H1B. And that means that the grace period has already started. There are only some exceptions to that. So, for example, if you ask to go on voluntary leave for medical reasons or family emergency or something like that, then you will be counted as maintaining your H1B even if you are not working and not getting paid. Somebody just recently talked to me about this one as well. And an example would be if you're a woman and you are pregnant and then you go on leave under the Family Medical Leave Act, FMLA. That is the same act that every American gets 12 weeks off, and then they can come back to their job. So if you take 12 weeks off to go give birth and stay home with your baby, you can go back to work and you still have your H1B. Or if you voluntarily send the message to your employer saying, hey, I have a family emergency, I need to take care of my children or my wife or my parents or whatever, and then I will come back. Then if they approve that leave, just save those documents, whether it's emails or letters or whatever it is, and later you can use that as evidence that you were still maintaining your status even when you don't have the pay stubs to show for it. But if you are on garden leave, meaning that you're not working and you maybe get only a fraction of your full paycheck, then USCIS can consider you as already losing the H1B.
Yeah, this is very new to me. So I thought, okay, the last day of the payroll is the last day of the H1B. So next day the grace period starts. But as you mentioned, it's the last day of the work. Okay, it's very interesting.
Right. So sometimes you do work and you get paid, 10 days later or 1 week later or something like that. So you have to be careful there on how you count the days to make sure you don't go over. But if we are considering the new trend of even people inside the 60-day grace period getting denials, then I would say never leave anything to last moment anyway. File change of status cases as soon as you can. So I would say if you get laid off on a Friday, then over the weekend go to my.uscis.gov, create an account, and you can submit the I-539 change of status application for B1, B2 online by just paying the fee. And you can, get the case submitted and receipt notice and everything that same weekend, and that would be a protection. If then in the next week or two you find a new employer who wants to file a change of status, you can withdraw the B1, B2, and then just apply for the H1B change of employer. So you still have, old H1B, and then you're within the 60-day grace period, and then you file the new H1B. But at least you have that pending change of status to protect you in case you don't find an employer and it was filed super close to the layoff date, so that you have maximum chances that nothing is going to go wrong.
Yeah, it makes sense, Henry. So I have the question on that. So you said the change of status from H1B to B1, B2 as a protection. So when I just change of status from B1, B2 to the H1B, do I need to go back and do the stamping and come again, or no, we can do everything inside the USA?
You can do everything inside the US as long as there hasn't been like any kind of violation, right? So if there's some kind of status violation or anything, then USCIS will say you're not eligible for the change of status. But if you have had your H1B, then you did a change of status to B1, B2, and then again you're changing back to H1B, then there should be no issue for a majority of cases, and that means you can stay inside the US.
Okay, it makes sense, Henry. So do we have any other option other than that B1, B2?
There are other visa categories depending on citizenship, but one of the most common ones nowadays that a lot of people are looking at is the O1. It's the temporary version of the extraordinary ability, right? So we have the EB1A, that is the green card. If you are accomplished enough to get an approval, then you can self-petition. And then you have the O1, which basically has the same criteria requirements as EB1. But in practice, EB1 standard is somewhere over here and O1 is here. So it is easier to get approved for an O1 than it is to get an approval for an EB1.
Wow. Yeah, that is a great news, because this is the first time I'm just hearing about the O1 is then opportunity. Suppose if someone got laid off H1B. So people, if you are in this situation, please contact the manifest law regarding the O1 visa, because you may be eligible for the O1 visa. So how long does it take to move from H1B to O1 if they are eligible, Henry?
Similarly, like the H1B filing, you can get premium processing, and then USCIS has to respond within 15 business days. The main issue with the O1 is preparing the case for filing, because it's similar to the EB1. You may need some recommendation letters. Usually the attorney cover letter can be anywhere from 20 to 50 pages long, making all of the arguments of why you qualify. And that's why usually it takes us somewhere like 1 to 2 months to put the case together. So if you're looking at the H1B grace period that you just got laid off and you need to move fast, you would still be safer if you also submit the change of status to B1, B2, and then start working on the O, because if it takes too long to get the O paperwork ready, you risk falling out of status.
That is a good strategy, definitely, yeah, because yeah, you don't want to be the out of status at any point of the time, so you can move to the temporary status. Then O1 is the long time, so if you get approved it, then it's a good visa, so you don't want to worry about all the H1Bs kind of thing. O1 visa, do we have any cap limit like H1B? Because H1B we have 6 year and then we can extend using the I-140. Does O1 is having similar kind of restriction?
No, the O1 doesn't have any cap, number one. Like, there's not a limit to how many O1s can be issued in a year. And then also, there's no limit to how long you can have an O1. So the first O1 is up to 3 years, and then you can keep renewing it. If you are renewing the O with the same employer, then it's 1 year at a time. But anytime you change to a different job, even if it's with the same employer, or if you move to a different employer, they can ask again for the full 3 years. And even if you've had it for 2 times, 3 times, you can renew it. But most people are not going to stay on the O1 that long because, like I said, it is similar to the EB1. So if you can already get an O1 approved, then there's a pretty good chance that if you just do a little bit more work, you're also going to be eligible for the EB1, and then you can hopefully switch over to that, provided that you have an earlier priority date or it doesn't take too long.
So O1 is not the employer sponsored visa, right? So I don't require the employer job offer to start the O1.
You still need a job offer, but there is a little bit more flexibility compared to the H1B. So with the H1B, you follow the standard rule of 1 job, 1 H1B. So if you even have 2 jobs and they want to hire you at the same time, each employer must file their own H1B filing for you. With an O1, you cannot yourself as a private individual apply for the O1 and ask for this visa. It must be filed by either an employer or an agent. An agent is basically like a third-party company who will be signing the USCIS forms and asking for the O1 status on your behalf. I'll give you an example. I had a serial entrepreneur in Estonia, where I'm from, and they wanted to come to the US to bring their own startup here to the United States. At the same time, they also had 2 other startups in the United States who wanted to hire them for different jobs. So I built a case where there was 1 agent filing 1 petition, and in the petition, I included 3 different job offer letters. And then USCIS approved the case, and they got 1 O1 visa, and now they entered the United States and they are authorized to work for 3 different jobs at the same time. So there is more flexibility compared to the H1B. And it is great for people who are in the startup world, who want to have multiple different projects going on at the same time, because you don't have to file, every employer doesn't have to file a different case, and it is simplified. But you still need to have either contracts or job offers, because USCIS wants to see that you have specific work that you're coming here to do or that you're staying here for. They won't give you the O to then go and start looking for the job.
So a lot of interesting things you have given about O1, because this is the first time we are discussing about O1. And as Henry said, it is like the mini version of EB1A visa. If you are qualified yourself for O1 visa, you are having a better chance to qualify the EB1 visa. So that is a green card. Which is a jackpot. Wow, great, Henry. Yeah, great option you are given. So because people always think about the H1B to the B1, B2 always. So this is the other option. So do they have any other option, Henry, apart from these 2?
There are other options to consider, but for example, if all you have is an Indian passport, unfortunately, your life is more difficult because some of the categories of visas are only available to different citizenships, right? So, for example, if you have already achieved Canadian citizenship before coming to the United States, then you can qualify for an E. There's an E1, E2, TN. these are visa categories that are not available for Indian citizens. But if you have Canadian passport, you can get those. And E1 is a treaty trader. That means if you have a business in Canada that is doing enough business with the United States, then you can apply for a visa just from showing that revenue. To give you an example, I did an E1 for a Canadian food blogger and influencer. So they were, publishing recipes and videos on social media and this kind of stuff. And they were getting a lot of the advertising and brand deals from US companies. So we were able to show that they were making about $80,000 a year from the United States. And just from that basis that they were Canadian citizen doing business with US companies, they got the E1 visa, and it's a 5-year visa with multiple entries. So that means you get the visa one time and you can keep running your business and you don't have to worry for several years about renewals or anything. Similar to that, but a little bit different rules, is the E2, which is the treaty investor visa. So if you're a Canadian, or most European countries, unfortunately, again, not India, but most European countries have this agreement, and Canada too. If you are qualified, if you have the right passport for the E2, if you make an investment in the United States, then you can come here and get a 5-year visa to run this business, that you either purchased the business or started a new business. This is kind of like the EB5 light, because it is not a green card, it is a temporary visa, but it requires a much smaller investment compared to the EB5. A common example is Indian in Canada with a Canadian passport purchasing a restaurant or a gas station or a store or something like that in the United States, and then coming to the US to basically manage this business. And then there's no limit to how much you can keep renewing it. So I know families who have been running a business for 20 years on the E2, and then eventually one of their children gets old enough that they can sponsor them for a green card as a citizen, and then they can switch to green card. Lastly, there's the TN, right? That's for Canadian citizens and Mexican citizens for specific occupations. If you Google TN occupation list, you can see what kind of jobs are eligible for that. There is also an H1B one for Singapore and Chile, and similar thing for E3 for Australians. So if you move to Australia, get an Australian passport, then you can get the E3, which is kind of like a easier version of the H1B, because there's no lottery. You can just apply at the embassy. You don't even have to file with USCIS. You can just get the LCA done with a DOL and go straight for the consular application and get the visa stamp. So those are the main things that I'm seeing day to day. Oh, and of course the L1, right? For some people that works, but most people already know about that. But if you're inside the US, then you probably have very limited options for the L, because L usually requires you were working for somebody outside and then they transfer you in.
Yes, Indians having fewer options than the other countries' people, but definitely they can work it out. O1 is one of the best option I can see if they are eligible, so they can go towards the green card. Thank you so much, Henry. You just clearly explained about the 60 days grace period on the USCIS regulation, and you have given a lot of options to us. Thank you so much for your time, Henry.
My pleasure. Always good to see you, and I'm happy to talk about more of these other categories in more detail if people are interested.
Sure. Nandri.
Nandri.